We've got a call-in question from Carney. Carney, what's your question tonight?
Hey, Carney.
2 weeks ago, I was in a nail salon getting my nails done, and they had water on the floor, and they didn't have signs or anything. So what happened was I was walking, and I slipped and fell, and I fell on my back. So the first week it was fine, but the second week I got this horrible backache, and I still have a backache.
Yeah, and I wish she hadn't hung up so fast. The thing is here, okay, there's water on the floor. Where did that water come from? And, you know, just because there's water on the floor doesn't mean anything. You've got to prove the history of that water, so to speak. You know, if it's raining hard outside and everybody's coming in, tracking the water in and out, you're not going to have a case. The law even pretty much says that if it's raining, you, the plaintiff, should at least be aware that, you know, it's raining outside, and therefore when I walk inside, it could be slippery. So there's all kind of different factors, but just because there's water and you fell. But as far as the injury is concerned, if you're still hurting, you need to go see a doctor first and foremost and complain, get this documented that you fell. I don't know if there was a report done when you fell, whatever, but something tricky like this, you need to talk to a lawyer that handles these types of cases.
I imagine these claims are really difficult to prove because there's so many hurdles that you have to clear, you know, in order, I guess, for an attorney to want to take on something so challenging, you know, for one, but
Right.
There's just a lot of things that play into these cases, and they get pretty complicated.
Yeah, they do. I mean, especially with the, you know, car wrecks. I'm not going to say that, you know, representing people in car wrecks is easy, because it's not, you know, but you know, in car wrecks, it's usually pretty clear as to who was at fault. You know, somebody, you know, he ran a red light or she ran a stop sign. There's witnesses typically. Now, every now and then you'll get a he said, she said stuff. There's no witnesses and you don't know who is right and who's wrong. But in a situation like this, if you are in a car wreck, it's usually clear, but a fall, there's all kind of factors that could come in as far as notice and you know, how long it had been there and things of that nature.
Well, and you've hit on this a little bit, talking about contributory negligence and how if you contribute in any way to what happened, to, you know, you falling, that you don't recover anything. But that's not the case in other states. So how would it work,
Right.
say in Florida, if you fell at a restaurant, there was some water on the floor, and
Right.
what, you know?
Yeah, typically I will. I don't know the percentages in different states, but most states, like let's say in the state of Mississippi, if you're judged to be 10% at fault because of your accident, then basically they just take away 10% of your jury award or something of that nature. They take away, because they're going to count your negligence, even though it wasn't the main factor of your fall. They're going to count that in deciding how much you get. In Alabama, if you're a little bit at fault, you don't have a case, but it's still worth looking into, because there could be some more factors that we don't even know. So always check first.
And I guess, I mean, that's what the jury's instruct. If it gets to a jury trial, that, you know, a judge in Alabama would instruct the jury that if the
Right.
you know, if the victim in the case, if they contributed in any way to the accident,
Right.
that the jury should not award anything. But I
Right.
guess you can still make the argument of why they should be awarded an amount. And I guess sometimes juries could come back and award people even though, you know, they contributed.
Yeah, you know, the problem with these kind of cases, if you're not really sure of whether you have a case going to trial, it's very, very, very expensive to get to trial with all the depositions and mediations and things like that. So that lawyer is going to make doubly sure that, especially in a slip and fall, that you've got a case before they're going to take it on.